If you have a green card, you have probably seen headlines saying a shocking new U.S. immigration law was just approved for 2026, and you need to take immediate action. Here is the calm truth. Right now, based on the information in that viral claim alone, we cannot verify a specific new law, its text, its effective date, or any new deadlines. And that matters because acting on the wrong information can be just as risky as ignoring a real change. In the next few minutes, I am going to do 3 things for you. First, explain what a real immigration law change could realistically change for permanent residents and what would require official guidance. Second, I will break down who would be most affected if rules tighten and who is usually not affected. Third, I will give you an immediate do this and avoid this checklist that protects your green card status even if nothing changes at all. Here is the part most people miss. Most green card problems do not come from one surprise law. They come from everyday actions like travel patterns, missing notices, address mistakes, taxes, or not understanding how CBP and USCIS already apply existing rules. So instead of panic, we are going to focus on what is verifiable and what is controllable. Now, what do we actually know from the claim you saw? The claim says a new law has just been approved, that it impacts green card holders nationwide, and that there are immediate steps, risks, and deadlines. But it does not provide the name of the law, the text, the agency memo, the effective date, or any official link. That is your first red flag. In immigration, real changes leave a paper trail, a public law, a Federal Register notice, an official USCIS policy alert, State Department guidance for consulates, or CBP field guidance. When those are missing, treat the message as unverified until you confirm it. This is not me saying nothing ever changes. Rules and procedures change all the time, but we need to separate 3 different things: laws passed by Congress, regulations issued through formal processes, and agency policy or enforcement priorities that can change through guidance. A viral post often mixes these together. Here is a quick, plain English breakdown. A law can create new requirements, change eligibility, increase penalties, or change processes. A regulation can clarify how a law is implemented and may add procedural requirements. Agency guidance can change how officers interpret and prioritize cases within the limits of the law. The practical impact for a green card holder usually shows up in a few areas: travel and re-entry scrutiny, standards for certain benefits like naturalization, documentation and filing requirements, processing times, and enforcement focus for people with criminal issues or fraud concerns. So if you are hearing the words immediate action required, ask, required by what authority and effective when? Because if there is no official effective date and no official instructions, your best immediate action is verification and good compliance hygiene, not rushing into filings or travel decisions based on a rumor. Next, let us talk about who is affected versus who is not, because this is where people waste the most energy. If you are a green card holder living your life normally, with no major issues, most breaking news will not require you to do anything today. But there are groups that are always more sensitive to any shift in enforcement or paperwork standards. Bucket 1. Green card holders who travel a lot, especially those taking long trips abroad or spending more time outside the US than inside. Even under current rules, this can raise questions about whether you abandoned US residence. Bucket 2. Green card holders with arrests, convictions, or pending criminal charges, even older cases. Small details matter in immigration consequences. Bucket 3. People with old or inaccurate information in their records, like wrong addresses, name mismatches, or missing documentation of how they got status. Bucket 4. Conditional residents with expiring conditional green cards who must remove conditions on time. Bucket 5. People close to filing for citizenship who have complicated travel history, tax issues, or selective service questions. Now, who is usually not affected immediately by policy chatter? People who maintain US residence, file taxes correctly, keep their address updated, and have clean records, especially if they are not in the middle of a sensitive application. Also, many so-called changes do not apply retroactively. But do not assume that. The key is to watch for official language about effective dates and who is covered. Here is a bridge hook. Two groups are at highest risk even when nothing changes, and you might be in one without realizing it. Those groups are long-term travelers and people who miss mail from USCIS. Missing mail sounds harmless until you miss an interview, a request for evidence, a biometrics notice, or a deadline to respond, and suddenly you are trying to fix a preventable problem. So a big part of protecting your status is basic systems: address updates, mail tracking, online accounts, and document backups. Now, let us address what the internet often calls shocking. The idea that you can lose a green card instantly because of a new law. Myth versus reality time. Myth: a green card can be canceled overnight for everyone. Reality: lawful permanent residence is a legal status. Losing it typically involves a process, such as relinquishing it, being found to have abandoned it, certain criminal grounds with proceedings, or a finding of fraud or ineligibility. There are urgent situations, like being placed in removal proceedings, or being refused entry and pressured to sign documents. But even then, the details matter, and you often have options. Another myth: if you travel for more than 6 months, you automatically lose your green card. Reality: there is no single magic day where status disappears automatically. But long absences can create serious problems at the border and can break continuous residence for citizenship. And a trip of a year or more without the right planning is especially risky. Here is why this is happening, meaning why these viral claims spread and why people feel the ground shifting. Immigration is complex, and real policy changes often come in waves. New leadership priorities, backlogs, more interviews, more document requests, more fraud screening, or new technology at CBP and USCIS. When processing times stretch and people see more scrutiny, it feels like a law changed even if the underlying law did not. Also, certain years create more noise. Anytime there is an election cycle, budget deadlines, or major court cases, online content about immigration spikes. Add the word 2026 and it sounds official even when it is just a prediction. Here is the part most people miss. Even when nothing changes on paper, behavior changes inside the system. Officers may be trained to look harder at specific patterns, or forms may be updated, or certain evidence becomes more important. That is why the safest move is to build a strong compliance record and keep your documentation organized. Now, let us get real about consequences for green card holders, because this is where you can make smart choices. The biggest real-world risk areas are travel, taxes, and residence, and paperwork. Travel first. CBP officers at the airport or land border can question whether you live in the US. If you have long trips, repeated long trips, or you cannot explain your ties to the US, you can face secondary inspection, intense questioning, or, in the worst case, accusations of abandonment. That does not mean you should never travel. It means you should travel with a plan. Second, taxes. Filing as a non-resident, or not filing when required, can be used as evidence that you do not consider the US your permanent home. Third, address and notices. USCIS and other agencies expect you to keep your address updated. If you miss a notice, you may miss a deadline and trigger avoidable problems. Fourth, eligibility for benefits. If you apply for naturalization, USCIS looks at your continuous residence, physical presence, good moral character, and other requirements. A sudden rush to file because you heard a rumor can backfire if your travel history or documentation is not ready. Let me give you an example scenario, and this is a composite example, not a real person. Example scenario 1. Maria is a green card holder who works in the US but spends 4 to 5 months at a time abroad caring for a parent. She returns, stays a few months, then leaves again. Nothing illegal is happening, but her pattern looks like she lives abroad and visits the US. She shows up at the airport and gets pulled into secondary inspection. The officer asks where she lives, what her job is, and why she is away so often. If Maria has a U.S. lease or mortgage, pay stubs, a letter from her employer, tax returns, and a clear explanation, she may be admitted after questions. If she has none of that and says she is just visiting, that is where things get dangerous. A viral post about a new law is not what causes that risk. The travel pattern is. Example scenario 2. David moved and forgot to update his address. USCIS mailed an important notice related to a pending application. He never saw it. Months later, he realizes something is wrong, but now he has missed a response deadline. Again, not caused by a new law, but by missing a basic step. Now we are at the most important part: what you should do now. I'm going to give you a checklist in do this and avoid this format. This is general information, not legal advice, but it is a practical set of steps that helps most green card holders stay safe, regardless of headlines. Do this. Verify the claim using official sources. Start with USCIS official announcements and policy updates, the Federal Register for rule changes, and State Department travel and visa guidance if it involves consulates. If the viral claim cannot point to an official source, treat it as unconfirmed. Do this. Create or update your USCIS online account if you have cases, and set up reliable mail handling. Use informed delivery if available. Keep copies of every notice, and make sure your name is on your mailbox. Do this. Confirm your address is current with USCIS for any pending case, and follow the correct process if you need to update it. Do this. Build a basic permanent resident document folder. Keep your green card copies front and back, passport biographic page, admission stamps, I-94 history if relevant, past approval notices, marriage and birth certificates if you use them for immigration, and your last 3 years of tax returns. If you travel often, keep proof of ties to the U.S., lease or mortgage, pay stubs, employer letter, school enrollment, utility bills, and proof of immediate family in the U.S. Do this. If you plan a long trip, think ahead. If you expect to be outside the U.S. for a long period, talk to a qualified attorney before you go, especially if the trip could be close to a year or repeated long absences. Avoid this. Do not sign anything at the border that you do not understand. If you are put under pressure to give up your status, ask to read carefully and consider requesting to speak with counsel if possible. Avoid this. Do not file a major application in a panic without reviewing your travel history, taxes, and eligibility. Rushed filings can create inconsistencies that cause delays or denials. Avoid this. Do not rely on a single influencer clip or screenshot. If it is real, you will be able to find it on official sites and reputable reporting that cites the source document. Here is another myth versus reality moment. Myth: if you get sent to secondary inspection, you are in trouble and will lose your green card. Reality: secondary inspection is common and often just means extra questions. The key is your facts, your documents, and your answers. Be calm, be consistent, and do not guess. If you do not know an answer, say you do not know. Now, if you are in a specific group, here are quick, targeted moves. If you are a frequent traveler, keep a simple travel log with dates in and out, and make sure your U.S. residence story is consistent with your actions. If you are planning to apply for citizenship, pull your travel history and tax transcripts early. Review continuous residence and physical presence basics, and resolve any missing documentation before filing. If you have any criminal history, do not assume it is minor. Get your certified court dispositions and talk to a qualified attorney before filing anything or traveling internationally. If you have a pending petition or renewal, track deadlines, respond to requests on time, and keep copies of what you send. Now, what should you monitor next, especially if the claim says 2026? Watch for 3 things. 1. An actual law or regulation text with an effective date and a clear summary. 2. USCIS implementation guidance, like policy alerts, form updates, or changes to instructions. 3. Real-world signals like new notice language, new evidence requirements, or consistent reports from reputable attorneys and accredited organizations referencing official documents. If you see people claiming country lists, new fees, new bans, or new automatic cancellations without official citations, that is usually misinformation or speculation. Here is a retention hook. A small detail changes everything, and it is the words effective date and applicability. Even real laws often apply only to certain filings after a date, or to specific categories, or they phase in. So the practical question is not just what changed, but when and to whom. Finally, what if you get a scary letter, a border warning, or you hear someone say you have a deadline? Step 1. Do not ignore it. Step 2. Verify it. For USCIS notices, compare the notice number, your A number if applicable, and check your account or call using official contact methods. Step 3. Do not send original documents unless requested, and you keep copies. Step 4. If the issue involves possible abandonment, fraud allegations, or criminal grounds, get qualified legal help quickly because the stakes are high and timing matters. Now let us close with a calm recap you can save. Number 1. Right now, this viral 2026 immigration law change claim is unverified, based on the details provided, so do not panic or make irreversible decisions based on a headline. Number 2. The biggest real risks for green card holders are existing rules: long or frequent trips abroad, weak ties to the U.S., tax and residence inconsistencies, missed USCIS mail, and criminal issues. Number 3. Your best immediate action is a compliance checklist. Verify through official sources, secure your address and notices, organize documents, and plan travel smartly. Number 4. If you are in a high-risk bucket, like heavy travel or any criminal history, slow down and get individualized advice before you file or fly. Number 5. Watch for official effective dates and guidance, not rumors, and expect that if anything truly changes, reputable sources will cite the exact document. If you want, comment the general situation you are in, like frequent travel, renewing a green card, applying for citizenship, or waiting on a petition, and I will make a follow-up video focused on that path. Subscribe and turn on notifications so you do not miss the verified update if and when an official change is published. And remember, staying organized and consistent is how you protect your status, even when the internet is loud.